Welcome to SQE1 Preparation Criminal Practice. On this post, we're going to talk about remand limits and custody time limits by Street Lawyer, helping you to pass first time. FLK2 Criminal Practice Specification refers to this section about bail applications. It doesn't specifically refer to custody time limits or remand periods, but I'm going to cover it anyway in order for the sake of completeness. But please do watch the video on police and court bail as well. Learning outcomes are going to be covers this video and the video on police and court bails, but it's about applying the legal principles to real life scenarios involving remand and custody time limits. In the post that we talk about police and court bail, we'll be focusing on understanding the presumption in favour of bail and how it applies in different circumstances, distinguish between different types of remand, custody, conditional bail and unconditional bail, and identify how custody time limits operate in relation to different types of offences. There are two test your knowledge questions. Test your knowledge 1, a set of true and false questions. There's 9 of them. True or false, a defendant can be remanded in custody for any period without any time limits before trial. 2, true or false, the custody time limit for a summary offence is 56 days before trial. 3, true or false, remanding a defendant in custody beyond 8 days requires the defendant to appear beyond the court on every 4th remand. 4, true or false, if a defendant's case is sent to the Crown Court, they can still apply for bail in the Magistrates Court. True or false, question 5 is a defendant charged with an either way offence can be held in custody for up to 70 days before trial. 6, true or false, a defendant can be remanded in custody for 28 days if the case management hearing is scheduled. Question 7, true or false, a defendant is entitled to apply for bail in the Crown Court once the case has been committed there. Question 8, true or false, if a defendant has pleaded guilty, they can never be remanded in custody before sentencing. And then question 9, true or false, a defendant is only remanded in custody if they are a flight risk or dangerous to others. And then you've got question test your knowledge 2, which is Tony's charged with theft and an either way offence. Tony makes his first appearance before the Magistrates Court from custody and indicates a not guilty plea. The magistrates indicate that they are prepared to accept jurisdiction and the client consents to trial in the Magistrates Court. The client does not want a bail application making on his behalf and he is remanded in custody on the ground that he will fail to surrender. Which of the following is correct about the maximum time Tony can spend in custody between his first appearance in the Magistrates Court and the start of his trial? And is it A, 28 days, B, 42 days, C, 56 days, D, 70 days, or E, 182 days? And on the next, at the end of the post, you'll see the answers to those two test your knowledge questions. By way of an SBAQ tip, you need to be aware and know the remand and custody time limits when considering an application for bail and the next court hearing, and you can see that through the test your knowledge questions, hopefully. So what is remand? Definition is a remand is a decision to adjourn the case and decide what happens to the defendant. A remand decision will be necessary where a case is part heard, maybe the trial is not yet completed, committed to the Crown Court for trial or sentence, adjourned for PSR, pre-sentence report, or a decision needs to be made about because there's an appeal from the magistrates to the Crown Court. Court's basically got two choices: remand the defendant into custody or remand the defendant on bail pending further proceedings in court with or without bail. And basically the underlying purpose of this idea of remand is to ensure the defendant's attendance at trial whilst also balancing the presumption in favour of bail. And as I said, we're going to look at police and court bail in another post. So in essence, what are the three ways a defendant may be remanded? You've got them. 1, remand in custody. Defendant is held in prison or remand centre. Not very pleasant. 2, remand on bail with conditions. Defendant is released but must comply with specific conditions, e.g. reporting to the police station. 3, remand on unconditional bail. Defendant is released with no conditions attached. And when we look at the remand time periods, you can see that slide there. That gives you the remand time periods, pre-conviction and post-conviction. Please study it, keep it pause the video if you want to, and you can read it for yourself. What happens to a defendant when case is sent to the Crown Court? If a defendant's case is transferred to the Crown Court, they may still be remanded in custody or on bail until their case is heard in Crown Court. So sometimes as a defence lawyer you have to warn the client that, you know, at the Magistrates Court you might be remanded. If your case is then sent to the Crown Court on bail or in custody, if you on bail would be on condition, with conditions or without conditions. And then the other point that needs to be made here, and you can see it in red here, and you can sometimes pick this up in an SBAQ question. Magistrates can no longer hear bail applications once the case is committed to the Crown Court. So remember that point. Question: does a defendant have to appear in court for a remand hearing? Well, remanding a defendant in custody beyond 8 days requires the defendant to appear before the court on every 4th remand. The question: can a defendant who pleads guilty to be remanded before sentence? Yes, the defendant who pleads guilty but is awaiting sentencing may be remanded in custody before sentencing, often for a pre-sentence report to be prepared. And then we move on to another issue, which is about custody time limits. What are they? This refers to the maximum amount of time that an individual may be remanded in custody during the progress of a criminal trial. The aim is to try to expedite the case through the criminal justice system for those in custody. So it's not as if it's a limitless amount of time a defendant can be kept in custody. And this is a very important slide, and it's about a question about what are the custody time limits for various offences. And you can see I've split them up into summary, either way, and indictable. So for summary offences, the custody time limit is 56 days before trial, and the trial there takes place, remember, at the Magistrates Court. Then you have either way offences. The custody time limit is 70 days for cases sent to the Crown Court from the first appearance in the Magistrates Court to committal sending to the Crown Court. So if a case is being sent to the Crown Court, it's 70 days. When it comes to either way offences, custody time limit is 70 days before trial in the Magistrates Court. So if the case is kept in the Magistrates Court, it's 70 days unless the allocation hearing occurs within 56 days, which then reduces the time limit to 56 days. So where there's an allocation hearing and there's a right to elect of a defendant, then it's 56 days if the case is kept in the Magistrates Court. And then you have indictable offences. 182 days is the maximum period of custody when a case is sent for trial to the Crown Court from the time when the accused is sent to trial and the start of the trial in the Crown Court. Then we move on to test your knowledge. Number 1, which is the true and false questions. The 9 questions are there. Please feel free to pause the slide and video, check the answers, and there's a little bit of feedback as well. And then you have test your knowledge 2. Remember, this is about a case which is an either way offence. The person has an allocation hearing, and the allocation hearing takes place within 56 days of the first hearing. It happens on the first day of the hearing. And he decides the case to be tried in the Magistrates Court, so it's reduced from 70 days to 56 days. And finally, remember, watch all the videos in the SQE Prep Criminal Practice series. Understand the functioning legal knowledge being examined by reading the SRA website for yourself. Revise from a really good SQE book. Attend and participate in class. Prepare your Q&A flashcards. Practice as many of those SBAQ questions as possible. Subscribe to the channel, put your notification on so you don't miss out on more SQE prep videos. I really do hope you found the class useful. If you did, you know, put a like, put a comment on the YouTube channel. See you in the next class, and thank you for watching.